Welcome everybody to our National Employment Seminar with Elevation Recruitment. It's great that so many people have registered for this event. We've got over 300 registered, so that's fantastic. There's three of us speaking today. It's going to be myself. For those of you that don't know me, my name's Glenn Hayes. I'm partner and head of the three Northern employment teams at Irwin, Mitchell, Leeds, Sheffield and Manchester. And I'm going to hand over to Jenny Arrowsmith, who's another partner in the team in Leeds. And then finally, Padma's going to deal with the last parts of the talk. Padma's a senior associate based in Leeds and Manchester. We're going to start the seminar in a couple of minutes. It's disappointing not to see everybody smiling faces in person, and I hope everybody's dealing with the lockdown well and the ease back into work. We are going to be sending out a recording of this afterwards, so that will contain all of the slides and it will obviously show this event again. We also have a feedback link which is going to be up for completion 15 minutes before the end of the webinar. We're going to talk for probably around 45 minutes and then we've got about 15 minutes for questions at the end. If we don't manage to get your question answered, if you ask your question by providing your details, we will give you a call and we'll answer it in person. Hopefully that's okay for everybody. So I'm going to start the talk then and talk a little bit about the sort of where we are now. So obviously, as everybody knows, the national lockdown started on the 23rd of March. And many businesses were ordered to close their doors, so by law, so hospitality, shops, etc. But the government's never ordered non-essential work to stop, and indeed it's encouraged it to continue. Now, the government said that other sectors may be able to open from July, so including hairdressers, so it stops us having to have the COVID cuts. I've had 2 of them already. But it'll all depend on whether those businesses are considered to be safe, and that'll be a reference to the government's 5 main tests. So restaurants, pubs, likely to be the last sector to be open. Dentists are apparently open this week, and it looks like those dates are going to happen in July. But organisations have to contend with the reintroduction of the local lockdowns if the R rate increases. Hopefully that doesn't happen. A significant event on the timeline, though, there is the 13th of May, where the UK was actively encouraged to return to work if we couldn't work from home and the workplace was allowed to open. A massive one for me. My 2 children went back to nursery yesterday, so unlike the situation where I had a remote tribunal a couple of weeks ago and my 3-year-old daughter ran in naked and hid behind a curtain, I can now sit down and talk to people uninterrupted. Hopefully my wife will stay in the other room and not do something similar. But all essential, other essential shops can open on the 15th of June, and the outdoor markets and car showrooms can open as from the 1st as well. So it's hopefully getting back to some form of normal. If we just move the slides on, please. So in terms of how we get people back to work then, what the government have said is that in order to get people to reopen the doors and to ensure that people can return to work safely, because I think most employees need to work and but only if they can do so safely. The business can reopen if it's COVID secure, which is the new buzzword from the government. And what does that actually mean? Well, what it means is that you've got a duty to take reasonable steps to ensure that your staff can work in a safe environment. And if you identify risks, you don't have to eradicate them altogether, but what you do have to do is to reduce them to the lowest practicable level. So the HSE guidance on risk assessment says that you should identify what work activity or situations might cause the transmission of the virus, think about who is at risk, decide how likely it is that somebody could be exposed, and act to remove the activity or situation, or if that isn't possible, control the risk. And it's really that last one that's probably the most important. So once the risk is identified, you've got to take steps to effectively remove it or minimise it as much as possible. Now, the government guidance, obviously there's a lot of similarity between the two. The basic rules are that if you can maintain social distancing, you should do so. So for example, in offices such as ours, do people really need to go back to work? Well, at the minute, the answer is no. So we're continuing to work from home. But if we did need to go back to work, we'd be expected to put up screens. We wouldn't be sitting face to face. We'd probably be sitting side by side, as far away from each other as possible. And you can only really reopen if you've put in place suitable measures to control the risk of transmission. And the government's put in place the guidance documents in relation to specific sectors and types of work, and it's useful reading those for your relevant industry. It includes things like putting barriers in shared spaces, creating shift patterns, which is a big one for a lot of employers, because essentially it may involve changing people's terms and conditions to change the hours in which they work, to limit the amount of people working together. If your business uses shared spaces, you need to obviously work with the landlord and other tenants to identify and minimise the risk. And even if your employer provides all the equipment and issues the instructions, I think it's key for employers to realise that if you don't ensure that the instructions are being followed, then again that you might be in breach. So if you tell people that they've got a social distance and you don't effectively check it, or you turn a blind eye, then you might be in breach. Now, the supermarkets are obviously a really good example of how it's working, limiting people coming in, the barriers at the tills, one-way systems and the like. And I think that is relevant for a lot of businesses. But it is worth me stressing, though, that there's still the government advice and guidance for employers to take all reasonable steps to allow employees to work from home. And that's something we'll talk about in quite a lot of detail. Quite interestingly, the government said that employers shouldn't provide PPE as a precautionary measure against COVID-19, and it's only necessary to do so if you supply it to your staff or they work in clinical settings like a hospital. So you've got to determine whether it's necessary, and if it is, what type of grade you need, and you can't charge for it if you do provide it. But I think for most businesses, you won't need to do so. So there's two sets of general regulations that might apply here that you need to be aware of. The first is the Health and Safety Consultation with Employees Regulations 1996, and the second is the Safety Representatives and Safety Committees Regulations 1977. Two pieces of legislation I've never heard of until we've gone into lockdown. And what they are designed to do is enable you to develop, maintain and promote measures that ensure health and safety at work, and to check how effective those are. Now, the key things to really think about is that if you recognise a union and you've agreed to collectively consult a union health and safety representative, you have to discuss your proposals with them to make your workplace safe for the staff to return to. But if you don't have a union representative, then you need to consult with your employees directly as individuals or through workforce elected health and safety representatives. So you might need to consult under both sets of regulations, and if you're not sure, take advice. The key thing, and what we're seeing, is that employers really are actually quite good at doing the risk assessments. There's quite a lot of guidance online on how to do them. And remember, you've got to publish them on your website if you employ at least 50 employees. But quite a lot of employers, in my view, are going to their staff and effectively saying to their staff, look, how safe do you feel in return to work? Are there any things that you are concerned about? And it's really important that you talk to your staff in advance of any return. So what you need to do realistically is consult with those staff about return to work. And again, consultation involves giving information and taking into account what people say before making any health and safety decisions. So, consulting with them after they've come back is probably not going to be good enough. But the law doesn't actually state when you've got to consult by, for how long, but it does say it should be in good time before you reopen. And the idea behind the consultation process really is to allow time for your employees to consider the issues and provide informed responses to you about that return to work. It's quite interesting that I've got a lot of I know a lot of people in the education sector who send out questionnaires to their staff saying how comfortable you feel about return to work, for example, on a scale of 1 to 10. Is there anything we can do to make that better for you? And again, those types of approaches for people and taking on board what they say is very important to do that. Not only to try and keep your employees safe, but also to gently encourage them to return to work. So consultation doesn't remove your right to manage, and you're responsible for making the final decision. But if you recognise a union and they don't agree that it's safe for workers to return to work, remember that they can ballot the members and take strike action if there's sufficient numbers vote in favour of such action. And it's key for you to remember, though, that if you don't comply with the regulations, you will be committing an offence, as health and safety inspectors from HSE and local authorities can enforce the regulations where there's no evidence of consultation So it isn't just something you need to pay lip service to. Travel to work then. We've probably all seen pictures of the crowded buses and tubes in London, and been horrified probably by the pictures of all the people on the beaches at the weekend in hot weather. And it's clear that employers do have a duty in relation to the consideration of how people will actually get to their workplace, as well as keeping them safe whilst they're in it. So it's clear that social distancing is going to be impossible for many who rely upon public transport to get to work. So employers, in my view, have got to find out how the staff plan to get to work. Now, obviously, if people drive, then it makes things a lot easier. But you know, we're obviously based in Leeds city centre, and parking can be 20 quid a day. So, you know, if you can do something in relation to those things, then it will be helpful. But there's 4 really key responsibilities here. There's the health and safety legislation to take into account. There's the common law duty of care, and that's the duty to take reasonable care of the health and safety of your employees. And if your employee suffers harm, which is caused or materially caused by your acts or omissions, and that harm was reasonably foreseeable, and it's fair, just and reasonable to impose liability on the employer, there will be a breach under the common law duty of care. But remember also, from employment law purposes, there's also a duty of trust and confidence. So if you heavily lean on your employees to get in at a particular time, and it's going to be the busiest time of the day, for example, then you may well stray towards constructive dismissal territory if there's a breach of that trust and confidence by the measurements that you put in place, or your inability to adapt those start or finish times, for example, to allow employees to avoid those busy times. There's also a duty not to subject employees to a detriment or dismiss them for taking evasive action over serious and imminent danger, and that's something that Jenny's going to talk about in her part of her talk. So the HSE guidance on it's really limited, and it says that employers should simply think about how their employees should get to work, whatever that means. But what it essentially means is that you should identify people where people travel alone in their own transport, or walk or cycle. That's obviously the best thing to do, and try and encourage that. You should consider staggering the arrival and departure times so that people can keep to their social distancing rules. That would help, obviously, using the entry and exit points at different times. And you should also provide things like hand washing facilities, so running water, soap, paper towels, etc. at entry and exit points if possible. Ensure that people can wash their hands when they get to work and leave work. And if it's not possible, provide some hand sanitizer. But in my view, employers have got there's a bit more of an obligation effectively on them, rather than just saying, how do you get to work? Well, okay, I drive. Because the government's obviously published safer travel guidance for passengers, and that asks users to consider all other forms of transport before using public transport. So where there's no alternative to that, then you should be advising your staff to maintain social distancing, wait for another train if the one that they were going to get was already full, try and travel off peak, wear a face covering, avoid eating and drinking whilst travelling. And the key, I think, for employers is really to try and find out how staff will travel to work, see if they've got any particular concerns, only ask those who are willing and able to attend the workplace to do so if that's possible, assess each individual's situation individually to take into account their commute and general health, because it'll be different for some people. Some people live around the corner from work, some people live 50 miles away. And if you can try and support other ways for them to get into work, then you should do so, really. So I just wanted to mention finally, before I hand over to Jenny, this category of vulnerable people. So the risk assessments really should identify those categories of people who are vulnerable. And it's not just those people who have been written to by virtue of the government. And a note from personal circumstances, my brother was written to this week. He's got cancer, unfortunately, and he's been told that he's in the ultra vulnerable category, and therefore his shielding requirement has been extended. And it goes a bit further than that for the ultra vulnerable category, because they've been told that, or certainly he has been told, that if he goes out and needs the requirement for a ventilator, he will not be able to access that, because those ventilators are designed for people who they actually will be able to help. He's effectively beyond that stage. So you do need to speak to your staff who are shielding. You also need to consider those who are pregnant. And remember that pregnant women have got special rights, including the right to be suspended on full pay if the workplace isn't safe and no other work can be given. Remember, you'd have to give those people the safest work within your office or factory environment or whatever your industry is. Same for the vulnerable people. But also, bizarrely, the BAME members of staff have been identified as there's increasing evidence that COVID-19 adversely affects those. So it's not just the most obvious examples that will come into play with those with disabilities. And remember, the law in relation to reasonable adjustments would apply as well. So you will be expected to do things in that regard and make reasonable adjustments in that respect. So I'm going to hand over to Jenny now, who's going to deal with the next part of the talk. And I'll hand over to Jenny.
Thank you. So I'm going to spend a bit of time with Padma just looking into the future and what's next and the kind of things that you need to be thinking about. If you, well, unless you're in a really fortunate position and you haven't or don't anticipate any dips in your people needs, payroll costs, etc., then really what we need to be looking at is a few things, and this slide summarises them. I'm going to spend a bit of time just looking at the furlough scheme and the update that came through last week, and the changes that you need to be making now, whether you've got people on furlough, anticipate needing to rely on the scheme or otherwise. And then Padma is going to pick up and talk a bit about changing terms and conditions of employment and redundancies, which is probably the next phase coming out of this crisis. And what you need to start thinking about that right now. And this applies whether you're anticipating a temporary dip or a longer term downturn in work. Most organisations are feeling the strain from payroll costs to some extent or other. And of course, many businesses and organisations have accessed the furlough scheme. So if we just go to look at the furlough scheme, if you move on to the next slide, please. Thank you. So the schemes run with effect from the 1st of March to the 31st of October. But there was an announcement last Friday which effectively made some changes, and they were anticipated to a great extent, as far as we were expecting a point where the scheme became more flexible, which allowed employees to do to work part-time and then still be able to access the scheme. But that's coming a month earlier. So from the 1st of July, there is going to be that flexibility. But that flexibility is only going to apply to people who were furloughed as at that date. So you've got to have, if you want to access the scheme on an ongoing basis, you've got to have some staff who've been furloughed for at least 3 weeks before the 30th of June, which effectively means you haven't got long between now and the 10th of June to put those arrangements in place. If you've already got staff furloughed, then they're already qualifying for that ongoing support and access to the scheme. The scheme is then going to run for a further period from the 1st of July until the 31st of October, with some flexibility in there, like I say, where workers will be able to return on a part-time basis. The thing to add here is that we're still very unclear on how this is going to work, so we're awaiting guidance, and that's been a running theme really throughout this whole crisis. The announcements are made and then we're left with a lot of questions. If you don't already get our e-briefs, I'd encourage you to sign up for those, and you can do that using the feedback form, which will be sent at the end of this presentation. We keep a really close eye, and we're posting really regularly as and when any updates come through. But at the moment, it could work a number of ways. It could be, for example, if an employee is employed for 5 days a week and currently furloughed for the whole of that time, but they come back for 2 days, then is that 3 days furlough going to be paid at 80% of the 3 days pay? Or is the cap that currently applies of $2,500 going to apply? So if, for example, you have a part-time worker who comes back and they their salary for the time that they're working is near or at that cap, does that mean that they're not going to get any more money under the scheme? We just don't know yet, but like I say, we're keeping a close eye and we will update as soon as possible. So that's from July. Then moving forward from August, what the government is asking employers to do is start to make what they call a modest contribution towards the cost of furlough. So the slide summarises it there. So from the 1st of August, the government will continue to pay the 80% as now, but employers are going to have to start making the cost towards NI and pension. That then increases in 1st of September, with the government paying less towards staff costs. and the employer making up the balance in addition to the NI and pension costs, and that balance would be 10%. And then from October that increases to 20%. Now, if you are an employer who has furloughed staff and has agreed to top up from that current 80% contribution, paying a 20% towards staff costs, you're going to have to think, well, do we want to continue to top up to full pay, or can we not afford to do that? If so, you're going to have to be starting to revise your arrangements with staff. And also you generally need to look at, well, how long do we need to furlough people for? How are we going to start bringing people back? To what extent have we got work available for them, and how are we going to meet these costs? And it's when you're looking at those kind of things, I think you need to start looking in the longer term as well and thinking, well, does this mean ultimately we're going to have to make some changes to the number of people that we need, or the way that we need to deploy them? And that's where Padma's part will step in. But what's clear is you need to start looking ahead. And with that, Glenn's talked about a number of factors that you need to start looking at in terms of the health and safety, but I'm just going to cover off a few areas as well. If you move to the next slide, please. So when we're asking staff to return to work, and this includes when we're talking about bringing them back on a part-time basis under the furlough scheme, we've got to give them reasonable notice. We've got to bear in mind that you've got a lot of planning to do, and Glenn's touched on quite a lot of that in terms of looking at the categories of staff who are able to come back to work and making particular arrangements in relation to those that are more at risk and shielding. And that's certainly something that, of those employees that we've been supporting, starting to move to get back to work, and that bit is absolutely key. So get looking at that straight away. But bear in mind also that staff have childcare arrangements. Now, schools have gone back, but only to a very limited extent. It's only certain year groups. And I do a lot of work in the education sector, and what I do know is there's many schools that haven't opened. So we can't assume that people with young children necessarily have the childcare, and of course many parents are not obliged to send their children back to school if they're generally concerned about the risks, if their child has asthma or such like. So people will need to make arrangements with regard to the childcare, and there will be some employees as well who've taken an additional job. So what we'd just say there is give reasonable notice. You will need to revise your arrangements in furlough, and we're working with a number of clients to support with template letters and things to help them with those arrangements. So if you did need any help with that, please do let us know. And then a key part is the communication about the steps you're going to take to make the workplace safe. Glenn's talked a lot about that, but I just agree with what he said, really, that a very pragmatic approach to understanding what their concerns are, talking to them, and where you can agree things on an individual basis has definitely proven to be the most successful strategy so far, and very important for the reasons I'll come on to talk about as well. The red flag areas. Sorry, just the slide before, please. The red flag areas, just a couple of points on there. We've mentioned about the vulnerable and those living with vulnerable, but do remember as well that a lot of those people who are in that vulnerable category will also be disabled for the purposes of the Equality Act, and therefore there's a duty to make reasonable adjustments in relation to them. Think about if they can do a different role, think about if they need to come into the workplace, and then I'd just reiterate again about the duty of trust and confidence, which is absolutely key here. Okay, so moving on to the next slide then, please. Glenn was talking about health and safety legislation, which has been around for a long time, but we don't have to get into it in the same level of detail as we are at the moment, and this particular right is in that category, really. Within the Employment Rights Act, there is specific protection for employees not to suffer a detriment or be dismissed in certain circumstances, and it's not a highly litigated area, really. There is case law on it, but it's not something that we see as particularly commonplace, but I'd anticipate that this will become a highly litigated area. And I say that not least because, having advised a lot of employers in the education sector in the last 2-3 weeks, where unions are obviously expressing real concerns about the return to work, these type of claims have already been mentioned. And for the reasons I'll go on to look at, you can see why they'll easily become relevant. So this particular right says that where in circumstances of danger an employee reasonably considers there to be a serious and imminent risk, that employee effectively has some protection if they leave a place of work, refuse to return to work, or take appropriate steps to protect themselves and others. And by others, we're not just meaning their colleagues, it could be members of the public, and it could also be their family members. It's very, very broad. Now, this is obviously going to apply as you're trying to talk to your staff about returning to the workplace, but it will also apply to those individuals who come back to the workplace and, despite any reassurances you put in place, feel that they don't feel safe, perhaps because the safeguards that have been put in place haven't been adhered to generally or by specific colleagues. So it's something that you need to keep a watching eye on. The definition of employees is also fairly broad as well, because this comes down from European directive, and that European directive talks about it applying to workers. So whilst it's not expressly clear that it applies to workers, it is potentially it's highly likely, I think, in my view, that this could be a right that workers may well assert as well. And if you're looking at detriments, the kind of detriments we might be seeing is where you decide not to pay somebody, where they're suspended for their actions, where they're overlooked for promotion, or perhaps they're selected for redundancy over other people. And then dismissal could also include constructive dismissal, so where there's breach of trust and confidence. It's an automatic unfair dismissal. There's no service required to bring this kind of claim, and in addition to financial loss for compensation, they can also seek injury to feelings. So it's not only a broad claim, it's also potentially costly. So let's just look at that claim in a little bit more detail now on the next slide. In order to assert a successful claim, there needs to be, sorry, can we just move to the next slide? Thank you. There needs to be actual danger, but that's an objective test. But if you think about the situation we're in, it's going to be a really low threshold, really, in terms of somebody being able to assert in the circumstances we're in that there is clearly a danger out there, particularly at this time where there's a huge amount of debate about the government strategy and various medical advisory groups disagreeing with the speed at which the return to work is happening. Now, obviously, that will change as time moves on, but currently, I think it's going to be a very low threshold for employees to meet there. Then the employee needs to show that the seriousness and imminence of the danger is present, and that really is about the employee's reasonable belief. So it doesn't matter what you believe; it's about what they believe. And like I said earlier, that includes not only danger to them, but danger to their family or the public. Now, the cases that have been litigated here don't deal with the risk of infection from other employees in the use of public transport, but like Glenn was saying, that is a relevant factor for the safety of people getting into work. So all these things become relevant. There is a defence to this claim, but it's quite a high threshold for employers. You as an employer are not expected to rule out any kind of danger to your employees, but you to do what you reasonably can to manage that risk and avert the risks, and that's something that Glenn was talking about. And the same principle applies here, but ultimately where somebody, unless somebody was negligent in not attending the work, you're going to be in a difficulty to defend that claim. But there is grounds for defence, but it's really on a case-by-case basis. So I think for the purposes of today, we just wanted to flag it. And if you are in the situation where you're finding difficulties of getting somebody back to work, and they're not in one of those shielded categories, and you can't put in place individual measures that are agreeable with them, then do take legal advice, because we'll need to look at it on a case-by-case basis. What is worth just noting in relation to this before I pass on to Padma is this assessment of reasonableness is based on the whole circumstances and the knowledge that that individual has and the facilities that are in place in the workplace. And the level of communication about those measures. So again, going back to what Glenn and I said earlier, Really important to talk to your employees, really important to understand what their concerns are and try and address those on an individual and collective basis. And it will be a changing dynamic because the government guidance can be part of this knowledge. It's not just knowledge that you have imparted on them as the employer, it's knowledge generally. So the government guidance, what's out there in the press, and obviously these changing dynamics with the media and the medical advisory bodies. So that's just something to be aware of and be cautious about, really. Now I'm going to move on to Padma now, who's going to talk about changing terms and conditions and then redundancies.
Thanks, Jenny. So as Jenny said, I think as employers are going to have to start contributing towards the furlough scheme, the pot that's there, or it ending in October, a lot of employers are now looking towards what other cost saving measures can we do other than redundancies, and one of the ways is looking at making changes mainly centred around hours and changing pay. So if you're in that category, I think the first starting point is going to be what is the change that you're wanting to make, and then looking at your contract of employment to see whether there is a specific and express right allowing you to make that variation or change to that particular thing. And what the mechanism is for doing that, whether it be give notice or if there's a collective agreement in place around that, of whether there's a specific process and consultation process that you need to follow. Any clause that you're relying upon in relation to this needs to be very clear and specific. Any ambiguous wording that you see around that, there is a legal principle that it's always construed against the drafter, and in this case that being the employer who drafts the contract. So again, if you think you've got a clause in relation to whatever it is that you're wanting to change, just make sure that it is actually clearly giving you that right to make that change. What we are seeing quite a lot of is employers coming to us with the general flexibility clause that's in a contract that allows for minor changes here and there, mainly around working hours. That probably isn't going to be good enough to make the types of changes that we're going to see. So again, with changes to hours, pay, they go to the core and the heart of the contract. So a general flexibility clause probably isn't going to cut it. And even if you think you do have a unilateral clause that is very specific and allows a change to pay or hours, again, just be careful when you're exercising it and making sure that you're deemed to be acting reasonably when exercising that clause. Because again, for example, you might see clauses that allow for changes in working hours, and that you could probably use for tweaks here and there. But for example, cutting hours by 50% or 70% wouldn't be deemed as reasonable. So again, just be careful about how you're exercising those clauses and making sure that you're seen to be acting reasonably. So as I say, very fact specific, making sure that the contract allows you to make the change that you're wanting to make, because otherwise the risks to the business in getting this wrong effectively would be a breach of contract claim. If someone has more than 2 years service and they say the change is so fundamental that breaks either the terms of contract, so breaches it, or breaks the trust and confidence between an employer and employee, it might entitle them to resign and bring what is known as a constructive dismissal claim, or even the scope for potential indirect discrimination claims if that change disproportionately impacts on a group of employees. So for example, Glenn talked about changing hours and staggering working hours. So again, think about the impact that may have on certain groups of individuals who might need to get children to nurseries, childcare and that sort of stuff. So those would be the risks of applying something like that, so to apply it with caution. And going on to the next slide, please. If you don't have a specific right within your contract, the next step would be to try and agree the variation directly with the staff. or any recognised trade union or works council that's authorised or governed to deal with these types of changes. And also, one thing I'll come on to is about collective consultation. So again, if you hit certain numbers, you may be required to consult with staff through representatives. ACAS has issued some guidance in relation to this, which if you've not seen it, I do think is worth having a quick look at. It reminds employers that consultation of this nature is a two-way process, just by the nature of the word itself. So that means that employers need to explain the changes behind, or the reasons, behind the changes, inviting employees to talk to you about the change, air their concerns, even give different alternatives, because one thing that I saw right at the beginning of this process is employers going quickly to cut salaries and staff coming back to say, well, actually, to make that same financial saving, I prefer it if you took some of my benefits off me, or we agreed changes to my pension scheme, so that the hit isn't directly immediate, but we can still support the business in making that financial saving that you're saying you need to make at the moment. So do speak to staff to see whether they've got any suggestions or alternatives, because there may be other ways around this to get employees on board and get that engagement going. And the other thing is getting the tone correct in terms of the communications and what you're trying to say, because I think a lot of litigation you tend to see around this tends to come from employees not fully understanding why you're making the changes, what the impact is, and sort of bringing them on board and feeling that they've not been heard. So that's quite an easy win from a practical point of view of trying to get employees to be engaged in the process. If changes are agreed, then you need to confirm that in writing, whether that be through a variation letter, or if the changes are quite drastic from what the individual was currently enjoying with the organisation, I would suggest looking at giving a new contract that governs it all. And those of you that joined us at our last update seminar will be aware that any contracts issued from 1st of April need to be compliant with the new April changes, in that there's extra detail that you need to include in those contracts. For those of you on the webinar today that have our IMHR Plus retainer, that's covered as part of that retainer, so do make use of speaking to your dedicated lawyer or going onto the online portal to see the new up-to-date contracts that are required. But if changes are being made, then just make sure that you're documenting it, and also that your contract is post-April compliant. If agreements can't be reached, then you're in a situation as an employer to do what is known as dismissal and re-engagement. And as the wording says, it is exactly that. You dismiss an individual, but then immediately offer to rehire them on the new terms that you were trying to get through and agree with them. But it is something that does expose the business to a potential unfair dismissal claim. So you do need to make sure that you really dot the I's and cross the T's and follow a proper process, because ultimately you need to be able to defend an unfair dismissal claim if one does come about as a result of it. The dismissal in these types of situations will be for what is known as some other substantial reason. And so if you are having to go down this route, it is something that I would suggest is a last resort, and something where you are following that process because of the unfair dismissal risk there. And so my top tips for this would be, think about, have you done everything you possibly can to reach agreement? So is it that you need to word the reasoning slightly differently, or try and have another go explaining what you're wanting to change, why, how long for? Are they absolutely necessary? Because that will also be another question that will be looked at when considering whether this is a fair reason for dismissal under that some other substantial reason category. Think about your overall employee engagement, morale, and so on in terms of the process that you're following. And as I say, making sure that you give the correct notices, give them the rights of appeal, give them the rights to be accompanied, and so on, to help with that with that process and defending a claim should one come through. Again, as I said right at the beginning, I think communication is going to be the key throughout all of this. And so if you communicate to staff correctly in the tone that is right for the business and explaining what you're needing to do, most staff will understand the reason for the change that you're making and the difficulties. And you would hope that most staff would rather keep their job with the variations, whether it be a pay cut, change to hours and those types of things, rather than facing the risk of a redundancy, where we're in a climate where we're potentially hitting a really deep recession and trying to find a job in that climate. So going on to the next slide, the IOD lobby group has found that a quarter of 1 million companies that have been surveyed have indicated that they are considering making redundancies once the furlough scheme ends. And I mentioned collective consultation earlier, and that is where you're looking to dismiss 20 or more people within a 90-day period from one establishment. And if it's 20 or more, you have to consult for a minimum of 30 days before any changes are affected, and if it's 100 or more, 45 days before any dismissal. Now, in this context, the definition of redundancy and dismissal is a bit wider than what you may traditionally be used to, in that it's not just about not closing down a workplace or not needing as much work. It's a reason related to anything not related to the individual concerned. So what I mean by that is where they've not committed misconduct or a dismissal for those types of reasons. And therefore it's probably going to capture, or it is going to capture, dismissals where you're looking at dismissal and re-engagement. And the reason why you need to think about collective consultation right at the start of the process is when you start that consultation process, you will not know what percentage of employees will want to agree to those changes, and therefore what will result in dismissals, and whether you're going to hit that 20 cap. The fact that you're going to offer re-engagement is irrelevant for the purpose of this. You are still caught and the obligations are going to be triggered. So do think about whether or not your changes will affect 20 or more people, and therefore whether you need to start thinking about that collective consultation process. Because if you fail to comply with this obligation, if it's triggered, there are some significant penalties. So it's 90 days uncapped pay per affected individual, on top of any redundancy pay, unfair dismissal compensation, and so on. As well as there is an obligation to report Secretary of State through a HR1 form, and a failure to comply with that is potentially a criminal sanction. So looking at the next slide, consultation can't begin until you've got representatives in place. So if you recognise a union or works council, check the wording of that agreement that you've got, because one thing that you can't automatically assume is that just going back to the slide before that one, is that the agreement covers all of the employees that you need to consult with, and also whether it covers the type of change that you're wanting to make. So if you need representatives putting in place, you then need to think about how you're going to get those representatives elected. So especially when people are at home, furloughed, on unpaid leave and so on. So it's going to take longer to elect those representatives, and your communication rhythm that you normally have with staff when they're in the office is going to be slightly different as well. So my view would be you need to think about the ways of communicating with them through WhatsApp, Microsoft Teams and those types of things. Come August, you've also got a situation that a lot of businesses are probably going to have to start thinking about collective consultation, and because they can't subsidise even the national insurance contributions and so on. And so I would start, if you're in that category, I would start thinking about electing representatives now, if you think about how long that process is going to take, because by the time you elect them, it's probably going to be around late July, August time when you need to start using them to make the changes. Also, a point to note is probably how you're going to get the information across to those representatives. because usually in the workplace you find people going off to meeting rooms, canteens and so on to speak to the people that they're representing, whereas now that's going to be difficult, which does hit a GDPR type issue in that how are you going to share information in relation to phone numbers, personal email addresses and so on. So again, I would certainly make sure that before you kickstart all of this, you have a proper plan in place and all your ducks in a row to be able to get going really when you need to start consulting. Other tips that I would have is things like short bite-sized letters rather than one big letter, what works for your employer, for your employee workforce. And also I've started seeing employers film videos to deliver some of these messages, which gives a personal touch, but also gives that element of being able to explain and put some context around what you're trying to say, which sometimes can get lost in a letter. In the couple of slides before that, there is a mention of special circumstances defence, and what is meant by that is where you've got an obligation to consult and there's acknowledgement that there is an obligation to comply with that legislation, but the thing affecting the business was so immediate that you didn't have time to comply with it. It is usually quite a high threshold to get over to apply the special circumstances defence. So hands up, we should have done it, but we haven't done it, so please don't penalise us with the 90 days pay. There are questions and a lot of commentary around whether coronavirus would be a situation that would allow you to not fully comply with the collective consultation obligation. And my view in relation to this is that the furlough scheme offers a bit of a breathing space to allow you that timescale to be able to consult properly. So I think there'd be very few circumstances where employers can use that special circumstances defence. That's not saying that every business won't be able to use it, because there may be some exceptional circumstances. So if you're thinking about using the special circumstances defence, do get some advice and think about whether or not that would apply for you, so you can do a risk analysis of the benefit of speed versus complying with the legislation. The good news is that the government has specifically said that employee representatives who are furloughed can still act as a representative, and you can undertake consultation with staff without breaching furlough rules. And so I know that's one question that we've been asked quite a lot of, and as long as people aren't providing a service or making money for you, consulting with them or using them as representatives is fine. And just quickly looking at timing of redundancies, there will still be some employers that will need to look at redundancies regardless of the furlough scheme being in place, especially when you're going to have to start contributing towards that. And where that is the case, just think about the usual rules still apply in terms of assessing whether or not there's a redundancy situation, but you do have an obligation as part of that to look at alternatives. And so timing is going to be key. And I think whilst the furlough scheme is in place, you do need to be exploring with your staff as to why the furlough scheme isn't sufficient to kick that can along the line in terms of redundancy. And so why you can't use that as an alternative for at least now, rather than that redundancy situation. And I know, especially if you're unionised, do take some advice in relation to it, because I know the unions are currently kicking off anyone looking at kickstarting a redundancy process by saying we should be using the furlough pot instead. Going on to the next slide, in terms of notice, one thing that seems to be the case is that you can use notice pay to fund some of that, the furlough scheme, sorry, to fund some of that notice pay. There are questions around whether you have to pay full pay or just the 80% salary that you're currently paying. And I don't think the guidance is clear enough in relation to that, and there are two schools of thought in relation to it, in that either it's analogous to holiday pay, and so you can use it up to the 80%, but then you're required to top it up. But there are some contracts which will allow you to just pay the 80%, and that will involve looking at what notice periods you give within the contract. So if you think you're within that, again, take some advice, because it may be possible to pay slightly less but the belt and brace approach would be to top up the government fund. And then finally from me, going on to the slide entitled redundancy pay. One thing that the government scheme is clear about is that you can't use the furlough pot to fund the redundancy payment. And so just going on to the next slide after that one, the safest thing to do is to base redundancy payment on the pre-furlough salary. But again, there may be some contracts with some quirks in that would allow you to get away with paying the reduced salary. It tends to be the contracts without normal working hours, but the belt and brace approach would be to base it on the pre-furlough salary, and you can't use the furlough pot to fund that salary. So I'm going to hand over to Glenn just to quickly go through the to-do list and then hopefully take some questions.
Okay. Thanks, Padma. Okay, well, we've got quite a lot of questions to go through, so I'm going to try and answer as many of them as I can, and if I can't answer them, I'm going to hand it over to somebody who's infinitely more intelligent than me to do so. The first question really, and it's one that's been asked by a number of people, is this issue about people who have been furloughed and returned to work or are rotating between furlough and work, and whether or not, in essence, post July, you can continue to effectively claim for those people if they're not actually furloughed at the end of June. Now, rather unhelpfully, the guidance I don't think deals with this at the minute, but I think the spirit of what's been said probably does. So I'm going to stick my neck out, but I'm going to make it subject to the fact that further guidance is due predictably on a Friday night, which is the 12th of June at 5:30, which is always the time that the guidance comes out. But what that says is that as long as somebody's been furloughed for 3 weeks, the guidance seems to suggest that if it's closed to new entrants. So my personal view would be that if somebody's been furloughed and you've claimed for them under the scheme, even if they're not furloughed at the end of June, okay, my view is that you should be able to claim for them under the new furlough rules, notwithstanding the fact that they weren't on furlough at the time that they're kicking into the flexible furlough scheme. Now, I can't 100% with certainty say that, but it seems to suggest that because it uses the words new entrants, my view would be that if you've claimed for people before, you should be able to claim for them again, even if they're not on furlough at the end of June. Watch this space and certainly watch the guidance from the 12th of June. In terms of some other questions, then we've got a question about people who are living with shielding partners and pregnant partners. Where do we stand in asking them to return to work? Well, carefully, I suppose, because remember that disability discrimination not only protects the person with the disability, but you can discriminate against people on the grounds of disability, and it doesn't have to be theirs. So you should really consider whether there's less risky work for them to do, whether they can work from home and the like. It doesn't just protect the person who is pregnant themselves or shielding. So just be a little bit careful under the disability legislation in terms of the shielding point. In relation to the pregnancy point, my view is that you need to take into account the risk that can potentially cause and discuss it with the employee. But if they can't return to work and they can't work from home, then there's no obligation necessarily to pay them. They can avail themselves of other types of leave, such as unpaid leave and time off for dependents for emergencies, for example, which obviously applies in the school situation as well. And just be careful, though, because obviously one alternative to potentially terminating somebody's employment might be to keep them on the furlough scheme for as long as you can recover money from the government. In terms of risk assessments being published on a public-facing website, somebody's rather helpfully pointed out that they haven't found any examples on websites, including Irwin Mitchell's. I'll have a look at that. But what the guidance essentially says is that you should consider publishing the results on a website, and then it goes on to say that the government says we would expect all employees with over 50 employees to do so, and so it probably means that you should, and it should be somewhere public facing. I don't think you have to put it on your front page, for example, but you should have probably some link to it from your front page, in my view, albeit it doesn't appear to be a sanction for not doing so. Somebody's asked a question about the responsibilities that a landlord should be taking because they're tenants in an office. and they've assumed that the responsibility of health and safety of employees and visitors is theirs, but what should the landlord do? The honest answer to that is I don't really know. I think the employers that we've spoken to are speaking to landlords and getting cooperation to assist them in their obligation in relation to employees. So, for example, by changing the entry systems to allow safe entry one-way systems, for example. But I'm not sure what the individual responsibilities on landlords are. Joe, perhaps I can get one of our real estate people to give you a call on that separately if you just if you're keen for him to do so. The other questions that we've got relates to people who have taken a pay reduction. So does it need to be in writing rather than just verbally in an all staff email? Well, the answer to that, Dawn, would be that things in writing are only evidence of what happens, what an agreement is. It doesn't mean that it's not been agreed. So if you've got an agreement with, say, me to take a pay cut and I agree to that, that's fine. Obviously, it would be better if it was laid out in a document, because if I then end up in a tribunal and say, well, I didn't agree to that, then you've got an obvious issue there evidentially, but it doesn't necessarily have to be, in writing in that regard, or in somebody's contract of employment. Obviously, there's issues about whether it's a temporary pay cut, a permanent one, etc., which you need to think about. So it will be better to have it in writing. Somebody's asked a question about changes to job descriptions and flexibility in relation to duties carried out, and because if they introduce more working in pods due to the test and trace system, they'll need staff to be more multi-skilled. Well, again, I think that's an assessment for your business. Realistically, I think you will need to consider whether or not an individual can do their role, whether there's certain additional things that they need to carry out. And you may have the flexibility within your contracts to change that. If not, then you will be in a normal process of consulting with the employee to make changes to their terms and conditions as per normal. It's quite interesting. We had a question last week on a different webinar that we did about the test and trace system and about the obligations on employers. And what happens if somebody refuses to effectively be tested when they come into the office for temperature? And my view on that was relatively simple, insofar as, well, it may raise an inference that somebody's not able to work and therefore may need to be sent home. We've got other queries really in relation to somebody who's on sick leave, which started pre-COVID and is due to end on the 14th of July, and the cancer treatment will put them in the shielding category. There's no work that they can do, and it looks unlikely that they'll be able to return to work, and there's no other roles for that individual to do and can't work from home. What are the options to part company? Well, in my view, this will be a normal capability dismissal, save for one of the options may be to keep that individual on the furlough scheme if they're furloughed already, as an alternative to dismissal in the immediate short term. I think what you would need to do is to discuss with that individual and the nature of that treatment, how long they're likely to be in the Uber risk category, and to sit down and have some dialogue with them. Obviously, weigh up the need for the business to get that work done, as opposed to the detriment to the individual of losing their employment. So, in my view, it's a normal capability dismissal, save for there are obviously alternative options available to you as an employer with the introduction of the furlough scheme. In terms of reasonable notice about bringing people off furlough and return to the workforce, there's a question being asked about that. In my view, there is no set time scale for that reasonable notice, and it will change depending on the individual circumstances. So obviously, the more notice that you can give, the better. It's sufficient notice to allow employees to sort out whatever they need to sort out to be able to return to work, so childcare and the like. That might be easier now. In some circumstances like mine, for example, where my children have gone back to nursery, it might not be the same if in Jenny's, where the school's only open for 2 days a week, for example. So there's no set time scale, it's just whatever's reasonable. I think that will change depending on the circumstances. In terms of who has the final decision to return back to work in charity situations, whether it's a CEO or board of trustees, I think that will depend on your governance documents essentially. But in either case, ultimately, it's the employer, so it's whoever's got authority to make that decision, in my view. We've got actually quite a lot of questions. I'm just conscious of time. James, do you want me to keep going, or should I deal with these questions separately to people?
I think, Glenn, given time, it probably is worth if we can answer just a couple more and then maybe follow up.
Okay, yeah. So I'll just deal with a couple more. Quite an interesting question in relation to whether or not it's fair to change the terms and conditions of some employees and not others, i.e. those who've been furloughed, continue to work on the who've not been furloughed and continue to work on the full line, continuing to receive pay, while those who have been furloughed have the salary temporarily reduced on the return. Well, I suppose whether the question is whether that's legally or morally fair, probably different. I think morally it does seem fair to me, and it may well give you a justification if you still need to make temporary changes to people's employment, but you'd still need their consent to reduce the salary of those people on furlough on their return, and they may not give their consent. If you then need to go through a process whereby you have to force that issue through by terminating and re-engaging, then one of the factors that you may take into account, I suppose, could be the fact that you're trying to balance things up for everybody and you only need a partial saving in that regard, and therefore you should affect only those that haven't, have previously not worked and had in theory, a benefit before. Albeit my kids going back to work was to nursery certainly was a benefit to me of not having them around, quite frankly, in the nicest possible way. And then I suppose lastly, then if somebody's got underlying health issues, and the example's been given as COPD, whose decision is it whether they're safe to return to a risky environment? Well, essentially it's a joint one in my view. Ultimately that person needs to be comfortable in coming back. They may be in that position of serious and imminent danger that Jenny's talked about. But ultimately, if you've got work for them to do that can't be done at home, and there's no alternative for them other than to return, then it may well be the employer's decision following consultation with that employee. And if they can't return, then you may need to take a stance that, I suppose the far end of that stance could be terminating an individual's employment. Okay, I'm going to call it a day there. We have got some other questions, and what we'll try and do is we'll try and come back to people individually on those. I just wanted to specifically mention a couple of things really. One is that if you go onto our Irwin Mitchell website, we've got a specific section on what we've called the coronavirus hub, which you may find very useful, which James has just put up the slides for there at the end. And I'd also be really grateful if you could provide us with your feedback in the Q&A box. Again, there's a survey for you to complete, which will be really helpful to us. And if you've got any feedback as to what you would like us to do going forward, bear in mind we're in a brave new world, then just give us an email or drop us a line on the Q&A, and we'll endeavour to take that into account or fill it out on your feedback forms. Just to say, from my point of view, thanks very much for listening. I hope you found it useful. It's been a fantastic attendance. We've had well over 200 people on this, which is great news. It's disappointing that we can't see all of your smiling faces, but if anybody wants to chat with us, then by all means drop us a line. All of our details are on the slides at the start, and we'll endeavour to give you a call, and we'll catch up and have a quick conversation. We'd be happy to do so. So that's it from me. I'll thank you on behalf of Jenny and Padma as well. Thanks for listening. As I say, we'll try and come back to you individually in relation to those questions. Thank you.